Sorry, folks, if you're watching, give us just a few seconds. Yes, okay. So hi, folks. Thanks so much for joining us today. It has been a wild morning for many of us who work at Lambda Legal and work in LGBTQ rights. Many of our partners have also been watching and waiting for a very long time with us. So we're very excited to be here. My name is Ariel Goldberg. My pronouns are she, her, hers. I am Lambda Legal's Deputy Digital Director. I've been with the organization for over 7 years now, so I have been working on employment discrimination, not in a legal capacity. I cannot pretend I'm a lawyer, for a very, very long time. This has been a long time coming. So we have 3 Lambda Legal attorneys with us today, and I'm just going to ask folks to introduce yourselves, tell us a little bit about yourselves and how you've been involved with the cases. So I'm just going to shout you out and go from who is first on my screen, which is Omar.
Hi, Ariel, and thanks everyone for joining. You know, today's such an exciting day. My name is Omar Gonzalez Pagan. I'm a senior attorney at Lambda Legal in New York. My pronouns are he, him, his. I've been with Lambda Legal for 6 years, and a good chunk of that time has actually been working on these cases. We have been briefing and arguing coverage cases before the courts of appeals in so many states and circuits, including the SARDA case, which is one of the cases the Supreme Court decided today. And so this is a long time coming, and we're just very ecstatic about the outcome today.
Thanks so much, Omar. Karen, you're up next.
Thanks, Ariel. Hi, everybody. I'm Karen Lowy. I'm senior counsel with Lambda Legal. I use my pronouns are she, her, hers, and I've been doing state and federal anti-discrimination work on behalf of LGBT people for almost 2 decades. And here I'm part of the Lambda Legal team for the Evans case, which I know Omar is going to talk about shortly. Worked really closely with Greg Nevins, our chief workplace fairness guru, on the brief for the Bostock and Zarda cases, and I took the pen for our brief in the Stevens case, and it is being a part of this team with Omar and Greg and all of the other Lambda lawyers who have Diana and Sharon, everybody who has just worked their tails off to bring us to this day is just incredibly exciting. So I'm excited we get to talk about this.
Yeah, me too. Thanks, Karen. All right, Diana, you're up.
Thanks. I'm Diana Flynn. I use she, her pronouns. I'm the litigation director at Lambda Legal. I've been with Lambda for just over 2 years. Before that, I was with the U.S. Department of Justice Civil Rights Division for over 30 years, actually. Most of it as chief of the appellate section of the Civil Rights Division. We actually led the internal fight to get Eric Holder to decide that Title VII covered discrimination against trans people after quite an internal debate, and handled the enforcement after that. That, of course, was summarily reversed under the Trump administration, but the Supreme Court has just told them we were right all along.
Great. Thank you all so much for joining us. So the way this is going to work is I'm going to ask our attorneys a few questions about what happened today, how we got here, what this all means. If you have questions for them, you're welcome to comment below. I'm not sure we'll have time for them, but if we see anything glaring in the comments, we'll try to address it here or possibly write you if we can. So let's get started. But before we do, I just wanted to say that this discussion can't happen without us acknowledging that employment is an enormous predictor of survival and safety for folks in marginalized communities, particularly for Black trans women, many of whom can't even access getting employed, let alone being fired. I think it's worth mentioning, so the National Center for Trans Equality, which is a partner of us in many ways, released the results of the National Trans Survey the 2015 US Transgender Survey in 2015 that found that 38% of Black trans people were living in poverty and 20% were unemployed. Obviously, these numbers were not have anything to do with the COVID-19 pandemic 5 years ago. The survey also found that 12% of trans people had at some point been a sex worker, which is often faced with increased levels of policing. So it's important that we contextualize this victory within what's happening more broadly in the world. Just last week, 2 trans women were murdered, Raya Milton and Dominique Remy Fells. Yesterday, 15,000 people gathered in Brooklyn, which is where I'm from, to call for the violence to end. And I know folks have been protesting all over the country. So we celebrate today, but we also acknowledge that there's a lot of work we have to do. So with that all being said, let's jump into what happened. So the first question I have for you guys is, how did we get here? What are the cases and who are the clients?
Sure. And thanks, Ariel. And I think in telling the story of how we got here, we have to think both the micro of these particular cases, but also the macro. The result today is really the result of the work of years, decades really, of advocacy and sacrifice. Advocacy by colleagues of ours like Greg Nevins, who has been making this battle for a long, long time, and sacrifice from each and every one of our clients, and particularly from the clients in these cases, 2 of whom did not get to live the outcome of their cases, Amy Stevens and Donald Sarda. And, you know, justice delayed is justice denied. We cannot forget that. But we can also take some umbrage in knowing that their names will now be remembered and recognized for the incredible, incredible victory that they attained for not only themselves, but for others. So just going back a little bit in history, Title VII was passed in 1964, and debates about what it means to discriminate on the basis of sex have been happening for decades. At first, there was debate about whether it covers sexual harassment, then whether it covers male-on-male sexual harassment, and the like. And so for a long time, courts were rejecting the idea that discrimination based on sexual orientation was a form of sex discrimination. The reverse is not true when it comes to discrimination based on transgender status. We actually were achieving those victories as early on as 2000. And one of the biggest victories, one that is cited even throughout at some points in the opinion, Glenn v. Brumby, was a case that we brought and got ultimately decided in 2011, saying that discrimination against a transgender employee was a form of sex discrimination because it relied on sex stereotypes. And so these cases have been coming for a long time. In 2012, the EEOC finally sided with us and adopted the position that discrimination based on transgender status was a form of sex discrimination. In 2015, they did the same with regards to sexual orientation. And it was then that we started again to fight for more coverage victories in the courts. We represented Kim Hively, and we got her case taken up by the 7th Circuit Court of Appeals. She worked for Ivy Tech in Indiana and was fired because of her sexual orientation. And so we got the full court, what is called an en banc court of the 7th Circuit, to hear the case, and that was the first victory when it came to sexual orientation, and that was just in 2017. We also were representing Jamika Evans, another woman who was fired because of her sexual orientation and subjected to a hostile work environment. And that case, unfortunately, the Court of Appeals found itself bound by its prior precedents. And when we asked the Supreme Court, hey, you need to take this up, unfortunately, they didn't take that case. And that's actually how we get to Gerald Bostock's case, which comes from the same court in Georgia, the 11th Circuit Court of Appeals. And the Donald Sarda case is a case that we argued at the appellate level in the 2nd Circuit. And it was the second victory a year later in 2018. And that's the case that now was taken up by the Supreme Court along with Gerald Bostock's, as well as Amy Stevens' case out of the 6th Circuit. All of these cases revolve around the question of whether the employees were even covered by the Civil Rights Act passed in 1964? The answer was clearly yes. We were laying that roadmap with arguments based on textualism, based on the faithfulness to the text. And so these cases were pending for a long time. They were argued before the Supreme Court in October. As they were being taken up, we ultimately decided to participate in these cases along with all of the movement and strategize what would be the best way to make this happen. So we authored amicus briefs that were submitted to the court, two amicus briefs, and we helped organize along with our partners at ACLU, HRC, the Transgender Law Center, GLAD, a number of amicus briefs that would be presented to the court around, for these arguments. That includes a brief from 206 businesses, major businesses in the United States that sided with the employees. It includes briefs from professors, from academics, from former officials in the federal government, and a number of organizations. It actually included ultimately over 2,000 amici in total, and over 50 briefs themselves. And all of that is to say that we wanted to make sure that the court understood the question at issue. We laid the roadmap for that. And we wanted to also make sure that we lifted the stories of the people who were in these cases. So Amy Stevens used to work at a funeral home in Michigan. She was the funeral director of Harris Funeral Homes. And when she informed the funeral home's owner that she was transgender, the business owner immediately fired her. The Sixth Circuit Court of Appeals in March 2018 ruled that when the funeral home fired her for being transgender, it actually violated Title VII because it prohibits sex discrimination, and discrimination based on transgender status was both a form of sex discrimination per se, but also in violation of sex stereotypes. Amy Stevens passed away just a month ago on May 12th, and she didn't live to see the outcome of this case, but she obviously brought about a huge victory. She won at the appellate level. She now won before the Supreme Court. Donald Sarda was a skydiving instructor. He was fired from his job because of his sexual orientation. A federal trial court rejected his discrimination claim, saying that the Civil Rights Act could not have protected him as a gay man. He passed away in October 2014 while his case was pending. But in February 2018, the full Second Circuit Court of Appeals decided that sexual orientation discrimination is indeed a form of sex discrimination. And the court recognized that when a gay, lesbian, or bisexual person is treated differently because of discomfort or disapproval that they're attracted to people of the same sex, that is discrimination based on sex. And lastly, Geraldine Bostock was fired from his job as a county child welfare services coordinator when his employer learned that he was gay. In May 2018, the 11th Circuit Court of Appeals refused to reconsider its prior decision from 1979 that excluded sexual orientation discrimination from Title VII's sex discrimination provision. And that case was taken up along with Don and Amy's, and the court ultimately affirmed the wins for Amy and Don in the Second and Sixth Circuits and reversed the decision in Gerald's case.
Thanks so much, Omar. Just a quick follow-up question to that. In all of these cases, I didn't warn you, I was going to ask you this. So in all of these cases, they're kind of two-part cases, correct me if I'm wrong, where first you prove the claims on Title VII and then you have to go back and argue the case. Is that correct? Am I understanding that correctly?
Yeah, I mean, so the question that was presented to the court here was whether Title VII covers this type of discrimination. And so the court has affirmatively said that. Amy had already won, right, on summary judgment below. So Amy's case is really decided. But for example, that wasn't the case in Don's case. So now we go back down to the court for it to be, now that we know that it is covered, for it to be proven, and the same with Gerald's case.
Got it.
That's right.
That's helpful.
And
Thank you.
if I might too, along those lines, now that it's been established that there is coverage under Title VII, that step's done. From now on, it's just going to be proving the case. It's proving that there was discrimination, and that will be enough. But the big legal hurdle, we're over that one.
Great. So the next question I have is what happened? Like, what did the decision say? What did the court decide? Give us a little bit of a rundown of what that looks like.
Absolutely. I'll be happy to do that. And I'm really glad that where Omar left off was really with the individual stories of the plaintiffs here. I think that's incredibly important for us to remember. And before I even get into sort of the nitty gritty of it, I do want to take one step back. And that's just to say that, the earliest cases about whether Title VII, which is the federal law that prohibits employment discrimination, encompassed the discrimination that LGBT people have experienced. Those early cases really sort of treated those claims as facetious. They didn't engage in any of the real legal analysis about why what LGBT workers have experienced in the workplace is discrimination because of sex. That was the key question before the court here, is whether discrimination on the basis of sexual orientation, on the basis of transgender status, are forms of sex discrimination. And I need to point out that we've seen the way that the Supreme Court has recognized the dignity and humanity of LGBT people increasingly over the last many years. With the Lawrence case, with Windsor and Obergefell, that inevitably sets a stage here, right? That those atmospherics can't be underestimated, because there has been a shift in the narrative from viewing LGBT people as somehow different or other to seeing LGBT people as equal, with equal dignity and equal humanity. And that's inevitably setting the stage for allowing the court to stop looking at the atmospherics and really digging in on that core legal question. And I also just want to echo Omar that, just as with the marriage equality cases, this was truly another all hands on deck moment. With LGBT organizations, trans-led organizations, the entire community. And I just want to give a particular shout out to John Davidson, our former legal director, who is now with Freedom for All Americans, who did just an amazing job of wrangling and keeping everybody on the same spreadsheet and really, really making sure that this was the coordinated moment that it needed to be. And what we see in this decision, which has now squarely held that discrimination against LGBTQ workers is discrimination because of sex prohibited by Title VII, is that discipline, is that multifaceted argument that we all brought to bear before the court. This is in many ways a very conservative ruling. It is framed in completely straightforward textualist ideas, by which I mean the words of the statute apply, period, the end. That is what the court has held. We have laid out lots of arguments over the years about why the discrimination that LGBT people experience is sex discrimination, both because you can't really consider the ideas of sexual orientation or what it means to be transgender without considering sex. It's inherently baked into the analysis, into the question. It's relational. It's about your identity. It's about who you are romantically related to, but all of that turns on sex. It's about the sex you were assigned at birth versus your gender identity. All of what the court really recognized here is that sex is just a part of the calculus. There have been other arguments that we've made around sort of that relational argument, that drawing a parallel to interracial relationships, right? That courts have recognized under Title VII that discriminating against an employee because of the way that they associate with people of a different race was inherently race discrimination. And by the same token, discriminating against a worker because of a relationship with someone of the same sex is inherently sex related. We've made arguments around sex stereotyping, that where employment decisions are rooted in impermissible stereotypes about what it means to be a woman, what it means to be a man, what it means to be of any sex, that's inherently sex discrimination under the statute. But the court didn't go there. It didn't address either of those arguments other than in dissent, and instead really just set out a completely straightforward analysis that explains why, when an employer fires someone because of their sexual orientation or because they are transgender, that is inherently because of sex. It really, it is incredibly, I'll say that it's always setting aside the joy of winning and recognizing that this removes incredible barriers for folks who have experienced just hurdle after hurdle to equal treatment in the workplace, whether that's about getting a job or keeping a job or being able to be promoted or having access to the same kinds of protections in the workplace that everybody else is. There's something as a lawyer that is particularly gratifying in a wonky way, where you have worked really hard to provide the court with a roadmap, and the court walks right down that road. And that's really exactly what we saw here. And again, I want to give a shout out to our colleague, Greg Nevins, who has, been beating this drumbeat for years and years and years, and with just the incredible confidence and optimism that we were right, and that the courts were going to see that this analysis is inherently baked into the language of the statute, and that we were going to win. And I can tell you, presentation after presentation and CLE, and we've always faced the, do you really think you're going to get this result? And we just unwaveringly have said yes, because it's right, because even under this incredibly lowercase c conservative argument, right? I mean, our brief, in particular, our brief in the Stevens case, right? The part of what the decision did here was to say, what does sex mean? And now we made arguments that's not, the analysis under the statute has to be, what does because of sex mean? And that's actually exactly what the court addressed and made clear is applicable here. We, of course, rejected the notion that, the employers were laying out there that there's something inherent and biological about sex, and made clear that it's a much broader concept than what the employers were arguing here. But frankly, we said that even if you want to buy that, even if you want to go down that road, we still win. Trans employees are still covered. And that's exactly what the court said. Without buying into that framing, even if you're going to go down that road, it is still inherently because of sex when you treat someone differently because of the sex they were assigned at birth. So really, this is just a great recognition of the ways in which, when you discriminate against LGBT people, it is inherently because of sex. And I think we really all feel it's incredibly exciting to know that our optimism and our just fervent belief that this was, in fact, the way the law, you have to read the words of the statute, is correct, and what that really means for LGBT workers across the country.
Yeah, so first of all, apologies. There's a very raucous puppy here. And second of all, he's also very excited about this decision. And second of all, I just wanted to echo something Karen said, which was, I was fortunate enough to watch Greg argue at the Second Circuit, the Zarda case a few years ago. And his brilliance, his encyclopedic knowledge of law was just, I'm not a lawyer, but even I could tell it was something magical to behold. So thank you, Greg, for all of the work you have done for such a long time on this issue. So the last question I have now, the last question I have now is, where do we go from here? What does this mean for the broader movement now? What's next?
Well, if I might jump in there. First, while I completely agree this is a conservative with a small c decision, relying on the language of the statute and the principles of causation, it's also important to recognize that that principle is broadly applicable. And I think it will end up being hard to overstate the significance of the decision. While the court expressly said they were deciding only the Title VII rule, most of the federal statutes and state statutes, for that matter, that prohibit sex-based discrimination, prohibit it because of sex, a focus on the causation. That was language that the Supreme Court relied on to say, when you're looking at causation, it doesn't matter what your view of sex is. If you're deciding differently because of something about that person's sex, you violated the law. There's really no way to distinguish that principle from the Title IX context dealing with education, from the Fair Housing Act, from the ACA, or a variety of other statutes that prohibit federal sex discrimination. So this is going to mean a lot, not only because discrimination, being free from discrimination in the workplace is the foundation for a lot of other things, as you all have been saying, but also because the same principle should allow us to contest discrimination in all of those contexts in virtually every federal statute that prohibits discrimination, sex discrimination. Even in the Constitution, and Omar mentioned the Glenn versus Brumby case before, which was a constitutional case, the Supreme Court has applied the same kind of analysis. So we have a tool here that not only is going to be effective in going out and enforcing the law under Title VII, but should allow us to make strong arguments with respect to coverage, with respect to virtually every other federal statute prohibiting sex discrimination. So it's going to ultimately turn out that this is a decision that's going to have ramifications well beyond Title VII. I'd also want to say that while we're absolutely thrilled about this and we can't wait to get started, that does not make it any less important to pass the Equality Act. The Equality Act will shortcut a lot of this fight, and it also, for the first time, will guarantee the right to be free from sex discrimination and public accommodations, among other things. So we should continue that legislative fight as well. But in the meantime, we are completely thrilled to have this tool at our disposal. And also, I'd like to, while we have to talk more about this, I'd like to personally call upon the Trump administration to withdraw all of their positions and nasty little rules that are largely based on the kind of analysis about LGBT people and sex discrimination that was just directly, unequivocally rejected by the Supreme Court.
And that factors in a little bit into the rule that was dropped on Friday. I know I'm seeing a lot of comments from folks who are wondering if this will have any impact on our military cases, the trans-military ban, on the healthcare rule, and I suspect that it will. I don't know if any of you want to speak to that a little bit more in depth, but I mean, I'm sure you could legal nerd out forever about it, but I wanted to present the opportunity.
Sure. I mean, this is one of those situations that Alito was so mad that he called and cited all of our docket in so many areas of our work, saying that this will have implications, whether it's Karnofsky, our military, our challenge to the military ban, whether it is our challenge in Cato to the healthcare exclusion in North Carolina, whether it's some of the birth certificate work that we're doing. But more specifically, you know, just speaking just to the rule that was announced, that was finalized on Friday, and that they intend to publish this coming Friday. This has a huge bearing. For one, I would say that the Trump administration, and particularly HHS, has a little bit of pie on their face right now. They literally said that they would not wait for the Supreme Court's decision in the preamble to the rule, that they didn't think they needed to, and that they would rely on the views of the administration about what sex discrimination means. Well, lo and behold, as we were always saying, they were wrong. And so that is only one aspect of what is a very broad and dangerous rule. It certainly undercuts it. It certainly puts wind in our sails as we prepare to challenge this rule. We've already announced that, and we will be doing that. And if they were actually people who respected the legal process, who respected the law, I would if I were them, I would be withdrawing that rule. But we can always count on them being lawless and on them being callous. And so we're preparing a challenge, and we feel even more strongly about the wrongfulness of that rule based on today's decision.
As we said on Friday, we will see them in court. So we should watch out for that. So does anybody else have anything to add? Did we miss anything? I just want to make sure you've all said all the things in your heads before we wrap up.
One thing I'd like to say is that it's absolutely true that the Supreme Court in the past has increasingly recognized the dignity of LGBT people. But this is the first time that the Supreme Court has decided a trans discrimination case on the merits and upheld the rights and humanity of the transgender community. So that's something else to celebrate, that they've extended that trend to that important part of our community. And the trans people that have been waiting for this decision can breathe a sigh of relief.
Absolutely. And I also want to just give a shout out to dissents being prescient, right? In earlier in the Lawrence case, right, you had Justice Scalia predicting that the principles that were being announced would have these ripple effects and lead directly to marriage equality. And lo and behold, that was correct. So, it's great that Justice Alito is hating on our current docket, because we, as Diana said earlier, it's absolutely applicable. And, we look forward to all of those ripple effects being accurate under these really clear principles about what it means to discriminate because of sex.
Nice to agree with Justice Scalia on something. So thank you all again for joining us. I would be remiss if I did not mention that as we prepare a challenge to Friday's rule, and as Diana said, this is just the beginning, we have tons more that we're working on. You can help fund our fight if you just go to lambdalegal.org, lambdalegal.org/donate, or lambdalegal.org, wherever you can find us. This month for Pride, one of our very longtime donors, Anita Mae Rosenstein, is matching all donations up to $100,000. So your gift will be doubled, and you will be directly responsible for helping us sue the Trump administration and fighting for LGBTQ people living with HIV, and working for a better world for everyone. Thank you, Omar, Karen, Diana. Thank you all for following along on Facebook. And until next time. Thanks, y'all.
Congrats, everyone. Take a little bit of moment to celebrate.
Everybody go relax.
Yes.
And stay safe out there. Wear masks. All right. Bye.